Are you divorced with adult children still dependent on you? Hi, I'm Simon Dippenaar and I'm a family attorney. It is extremely common for children to be financially dependent on their parents after they reach 18, technically the age of majority. They may be attending further education or have not yet finished secondary school. Even if they have completed their education, they may have not found employment. It is completely reasonable for adult children to remain in the family home and for the parents to continue to support them. At what point it becomes unreasonable is a topic for debate, but that's not the purpose of this talk. I'm talking to you today because the Supreme Court of Appeal has recently passed a landmark ruling that has important consequences for divorced parents of minor and adult children. The court ruled that a parent can claim maintenance for adult dependent children from the divorced partner. Now, why is this so important? Well, because it resolved a question of law and interpretation of the Divorce Act, which had previously resulted in conflicting High Court decisions. Some of the decisions had held that a parent had the legal standing to claim maintenance, while others ruled that the children had to do so themselves. The judgment was written by Acting Judge Pieter Meyer, and 4 judges concurred with the decision. In terms of the Divorce Act, courts did not grant a divorce unless the welfare of any dependent child is provided for, and the court can make an order for maintenance, if appropriate. Judge Meyer's view was that the words of the Divorce Act taken in their proper context should be interpreted to mean that the parent can claim maintenance on behalf of the adult dependent children to safeguard the welfare of both adult dependent children and minor children. He said that any other interpretation would not be constitutionally valid. Very few young people are financially dependent at the age of 18, whether by choice, such as furthering their studies, or circumstances such as unemployment. Judge Meyer's view, supported by the other 4 judges, was that dependent children should remain removed from the conflict between their divorcing parents for as long as possible unless they elect themselves to assert their rights to the duty of support. It is undesirable that they should have to take sides and institute a claim together with one parent against the other. They should preferably maintain a meaningful relationship with both parents after divorce. This ruling will come as a relief to parents reliant on their ex-partner's financial support for a child approaching the age of majority. University or further education is expensive, and no parent should be left to fund this cost single-handedly, nor should a young person miss out on the opportunity to study. The only people who might not like this decision are those parents paying child maintenance, who are hoping they'd be relieved of the obligation when the child reaches 18. I welcome this judgment as it provides clarity on a previously grey area of law. If you have any questions about your maintenance arrangements or concerns about what will happen when your child reaches 18, give me a call on 086 099 5146 for a confidential discussion.